I know folks will be joining here over the next 5 minutes or so. So now we've become, at least moderately expert, Helen, at Zoom. First of all, great to see you here today, and thank you so much for joining us. I really want to take a minute to thank everybody for joining the conference today. As you'll see, there's a poll that's up for folks as you're joining this initial session. But before we get to the poll, before Helen and I start our conversation today, I want to say welcome to Spokes 2020. Spokes and this entire conference is part of WireWheel's mission and vision. Our entire team have taken our responsibility very seriously to try to help our community at all levels, the privacy and data protection community. And our community is out fighting to make sure that our companies and entities are trying to do the right thing with personal information, and that our companies are serving as those trusted custodians week to week on some very difficult issues around personal information. But we've also thought of Spokes as part of our critical vision for where we're going. And we started the company and we started Spokes with the idea that when it comes to personal information, when it comes to the way human beings around the world think of their own personal information, we've really seen it move to a tipping point in which people just don't feel like they have control over their digital footprints. They don't know who they're sharing it with. They often don't know what data is being observed about them. And even when that information is collected, they often don't feel like they know where it's going. And our vision is to serve as one of the critical hubs where people around the world, human beings, can really gain control of their digital footprints, which they leave behind as they live their lives. And so during the conference today and tomorrow, we've put together a set of panels and a set of experts that are focused on bringing critical insights on the handful of issues that the privacy and data protection community is really struggling with and facing every day. So we don't have 100 panels, we have a handful of panels. And we brought together some of the leading experts on almost every issue so that we can have a conversation with them about some hard issues we're facing day to day. As I welcome you to Spokes, I also wanted to take a minute to talk for a second to our entire community about some of the very serious civil rights and very difficult issues that have been coming up all around our country in the last several months. I myself, while I've had issues in my life at various times where I've faced racism, I can say that I can't really empathize and I can't really feel the pain and fear that so many folks in our community feel day to day. I don't wake up every morning in the same way worried about my kids and how they're going to be affected when they go for a run. And it's something that puts me in a place where I don't fully feel like I can empathize day to day. But that doesn't mean I can't stand with the community. And let me just say, for everybody out there that is feeling the rage and anger and repetition of what we're seeing day to day on some of the civil rights issues and some of the terrible events we've seen, just know that myself, our company, and all of us stand with you. And we're thinking about day to day how we do some of the hard things to more fully support that community. And yet, even in the middle of these tough times, there have also been some real glimmers of hope that we've seen on these issues, including just this week when the Supreme Court finally recognized LGBTQ rights in a very fundamental way. So, as much as and as difficult as it's been for all of us, I still do see a lot of glimmers of hope, and we're excited about the support that the community, our privacy community, continues to show around these difficult issues of civil rights and human rights. And the truth is, the privacy and data protection communities, we are used to hard issues. We're used to having to take on issues like healthcare and privacy, human rights, and the pressures that our community is under. And I'm really excited to have Helen today, who's been one of the leaders in that field, come to talk to us about those issues. And so, and one last thing before I do introduce Helen today, we're really hoping not only for Spokes in this way to serve as a gathering place for some of the hardest conversations and to bring in some of our deepest experts, but we also want to bring it together as a community where we can just reconnect. One of the things I've always loved about the privacy community, and when we've gone to conferences, is the fact that I love seeing folks in the hallway. It's a very open community in which you can actually talk to not only the experts, but the regulators, and have a dialogue and a conversation. And some of my favorite experiences are in the privacy world have been the day-to-day conversations I have around conferences. And just this morning, for example, we hosted a virtual yoga and mindfulness session that more than 60 of our community attended, which was just awesome. So throughout the day, we're going to have events that allow you to have coffee or learn how to make the perfect cup of coffee, but then reconnect with our community, at least virtually. And we're going to have cocktail hours and coffees, and our sponsors are hosting smaller events. And I do hope everybody has a chance to take advantage of those, because I think a lot of us miss each other, especially in this time of a COVID shutdown. So welcome to Spokes on behalf of all of us. And with that, I'm very excited to introduce our keynote speaker this morning. Helen Dixon has been a leader in the privacy and data protection space for quite some time. She is the Data Protection Commissioner for Ireland and has been since September of 2014. I think we've all seen how you've really overseen the transformation of the Irish Data Protection Commission, including through significant expansions of staff and budget, and through a lot of the transformations under GDPR. And of course, Ireland has been one of the lead supervisory authorities for so many of our leading companies and tech companies around the world. And especially with the one-stop shop, that means, Helen, you're really at the fulcrum of so many discussions today. So I realized that in a virtual conference, we'll all be applauding virtually, Helen, and cheering virtually, and you won't hear it quite as much. But I hope all of our attendees today, and we have an amazing group of participants, just a huge group of folks joining. I hope you'll all join me in welcoming Helen Dixon. Helen, welcome to Spokes.
Good afternoon, everyone, and very many thanks, Justin, to you and to Wirewheel for this really outstanding opportunity for the DPC to engage with a very broad-based audience today. By the way, we love the clever title of your conference. We're determined, if we host one, to come up with one just as good. This kind of event where we can communicate outwards as a data protection authority, and in particular engage in the kind of debate we will when we move on to the Q&A, it's a critically important role of data protection authorities, and it's one that we never really get an opportunity to do enough of. So really looking forward to this chance to deliver some opening remarks, and then coming back to you, Justin, to be challenged with some comments and questions. With 25 minutes, it's impossible even to cover any one topic in depth that I think we might want to talk about today. And I know as quite a varied audience, you're going to have different interests in terms of the data protection agenda. So what I thought I would do for the 25 minutes that I have initially is try and give you a whistle-stop tour of what an EU data protection authority actually does and is obliged to do. And obviously I'll do it by specific reference to my own office, with that context of all the tech multinationals that are located in Ireland. And as I go through the tasks, I'll dot in some reflections on what 2 years of GDPR has taught us and what I think is going to come in the next 2 years of the GDPR. So as is often the case when I start out on a talk like this, I'm probably going to try and cover too much material. I'm going to wreck the Zen buzz for any of you that have been at the yoga earlier, but maybe try and sit back and relax and catch the gist, maybe rather than all the details of what I'm trying to cover. And of course, I am focusing on the GDPR. I'm very conscious it's not the only show in town in terms of a legal framework, but of course it's the one that my office is obliged to regulate under. So that's what I'm going to focus on. And I think in any case, it's useful as other jurisdictions, including the US, grapple with the issue of a comprehensive privacy or data protection law. It's interesting to anyway reflect on what does or doesn't work well under the GDPR. At the outset, I think it's worth saying that data protection should be a relatively straightforward concept. In many cases, it involves the application of common sense and also a mindset that balances the rights of individuals and organizations fairly. And actually, a number of judgments recently in litigation in the Irish courts in which the Irish DPC has been involved, the judges in those cases have commented that long predating data protection laws, some of the specific data issues that are complained of and end up before the courts were anyway unlawful, either by reference to contempt of court or medical confidentiality. So these kinds of issues of treating people and their personal and identity data fairly have long been present. And of course, when we go into the cybersecurity side of data protection and the application of state-of-the-art security technologies, it does become a bit more technical and specialist. But I think we can say that in most scenarios of data collection and processing, it's definitely not rocket science, but sometimes it's rendered more complicated than it needs to be, particularly in the context of individual complaint handling. So as I go through my tour of the tasks of data protection authorities and the DPC under the GDPR, I'm not sure if this audience might expect that I would talk almost exclusively about the regulation of big tech multinationals, which is of course amongst the highest priorities of the DPC. But it's important today that I take the chance to set out the context in which regulation of the multinationals fits into the multiple non-negotiable obligations on the DPC as a supervisory authority. So the audience is probably aware we're an authority of about 145 staff. We'll increase to about 175 by year end. And in fact, we're one of the biggest of the EU data protection authorities, and certainly one of those with the largest complements of lawyers and technologists on our team. So I wouldn't dare bore you all into a stupor by reading out the tasks of an EU data protection authority, which are listed in Article 57 of the GDPR. But if you get a chance to look at it, you'll see it's a particularly long article of the GDPR, and it lists tasks from A to V, so A for abundant to V for voluminous. And it's very clear that we're not designed to be one-trick ponies, and I think that's very much reflected in the everyday work of the organization I oversee. But before I even get into those GDPR tasks, let me briefly make the point that the DPC, and this is the case for most EU data protection authorities, is also the supervisory authority for several other weighty pieces of data protection legislation. And at EU level, these include the e-privacy directive and the so-called Law Enforcement Directive. So under the e-privacy directive, each year my office takes successful prosecutions under the Irish regulations that implement it. We take those against large multinationals and telcos, smaller SMEs, any organization that violates the rules on direct marketing to individuals. And we resolve complaints on behalf of hundreds of individuals each year who end up being subject to marketing SMS, telephone, and electronic messages for which they do not give their consent. And these really do cause a nuisance. That e-privacy directive is also the directive that regulates the dropping of cookies. And the Irish DPC has recently taken the action, you may have seen our publicity around this. We've taken the action of conducting a broad-based sweep covering every sector of everyday websites that are accessed by people in Ireland in order to establish compliance levels with that directive, and particularly around the collection of consent for cookies and other tracking technologies. And actually the picture painted by the sweep was fairly diabolical. Of 40 websites that we reviewed, we found large-scale non-compliance, and most websites scored red in terms of the traffic light system that we implemented. So what we saw is that there are many badly designed banners for collecting consent and presenting information to individuals. There were a lot of cookies being set without any consent. Pre-checked boxes, which are not permitted, or sliders set to on, were being used. There was a lack of clarity on how consent could be withdrawn, or the options to reject cookies just weren't present. So it's a particularly important piece of technology in terms of the starting point of the tracking of individuals on the internet. And on foot of the sweep that we've conducted, the guidance that we've produced, we're going to commence an enforcement campaign in October based on the very clear guidance that we've now produced. The other piece of legislation I want to briefly mention is Directive 2016/680. This is known as the Law Enforcement Directive. It had to be implemented by EU member states by means of transposition into national law also in May 2018, the same time that the GDPR came into application, but in fact it's rarely spoken of. And my colleague Eunice at the DPC, she's described it as the Cinderella of the data protection laws. It's never invited to the ball or allowed share in the limelight of its beautiful sisters, the GDPR and the e-privacy legislation. But in fact, it's an extremely important piece of legislation, and the DPC since May 2018 has conducted investigations of use of technology in state surveillance under this directive. And it's resulted in the implementation of enforcement and corrective measures by the DPC in the context of police activity in Ireland. And I say that this piece of legislation is particularly important because Justin mentioned events that are rolling out in the US and all around the world. And this is the piece of legislation that in fact regulates use of body cams, drones, facial recognition technologies in law enforcement context. So it's a very quiet but prescriptive law that allows us to regulate in this space. And as a result of one of the investigations that we concluded under this directive, our police force had to switch off automatic number plate recognition cameras in one of the locations we identified, pending correcting its compliance with the directive. So two important pieces of legislation, but to move back to the GDPR and to look at those tasks under the GDPR. And in running through the tasks, which as I said, are quite considerable in volume, I'm not running through them so that anybody is going to give me a medal or to suggest or persuade you that we work very hard. What I actually hope you'll see as I run through them is that the tasks are substantial in many cases, and they're important tasks in terms of the effective implementation of a comprehensive every sector law that's designed to ensure that processing of personal data really does serve humankind. So there can often, we find, be very narrow conversations about what data protection concerns, and actually it concerns maybe a lot more than we talk about. So just to run through the tasks very quickly, and I'm trying to do them roughly alphabetically. Breach notifications, probably borrowed and inspired by US laws. The GDPR brought in for the first time mandatory breach notification to data protection authorities in its provisions. And in the first 2 years of the GDPR, the DPC has had almost 13,000 breaches notified to it, almost 200,000 across the EU. In the case of the Irish DPC, We, in fact, engage with every notification that's made to us. We individually assess and respond to each. On foot of several of the notifications, we've opened inquiries. Some of those inquiries are into big tech, one of which we've concluded. Some are into domestic organizations in Ireland. And in fact, already under the GDPR, we've issued fines in respect of some of the breach investigations that we concluded. As you know, those of you that are listening in from the US, this is an important provision, the breach notification provision, because for the first time, it's giving EU data protection authorities insights into whole swathes of areas of compliance or non-compliance, I should say, by organizations, and giving us an insight into areas where they're failing and falling down. We've talked before, an awful lot of the times it's the basics in technology terms, failure to keep patching systems, but it's an awful lot of failure to implement sound human systems as well. Binding corporate rules is the next thing I'm going to mention. You may be familiar with these binding corporate rules as a mechanism to effect data transfers under EU legislation. But in fact, binding corporate rules are a lot more than simply a transfer mechanism. They're an entire accountability program under the GDPR for organizations, and they have to be approved by data protection authorities when an organization that has multiple subsidiaries globally wants to implement binding corporate rules in terms of the transfer of data between the group. So it's a significant and increasing body of work for the DPC. We've 20 applications between controllers and processors on hand at the moment. We've 10 annual reviews to complete. We're seeing increasing applications to our office for approval of binding corporate rules, in part because of Brexit. And we're one of the DPAs in the EU that processes the highest number of these. But as I said, it's worthwhile work because we're reviewing an entire accountability program for organizations. Children. For the first time, the GDPR called out children as meriting specific protections. And in the US, of course, you've had the COPPA legislation for a long time, but up to this point, EU legislation didn't specifically single out children. In singling out children, however, it doesn't give us too many specifics as to how those protections for children are to be implemented. As a result, the Irish DPC launched a very large-scale consultation in respect of processing of children's data. We consulted very extensively with children, and we also consulted with adult stakeholders. Details have been published on our website if any of you are interested to have a look, particularly at the interesting views of children. We're about to publish a set of fundamental guidance now based on that consultation that will deal with issues of how and when children should be able to exercise their own rights, how children should be protected in online contexts. And then we're going to sit down, first of all, with the big tech platforms that are frequently used by children, and we're going to try and drive them towards a code of conduct that they would sign up to give us a better level playing field. But what we've learned from looking at the area of children under the GDPR, as with many areas of data protection, is that there are very differing views and that it's a very complex area that requires us to keep in touch with stakeholders that are more expert in this area. And we actually saw when the parliamentary debate happened in Ireland around Article 8 of the GDPR, which the audience might be aware is an article in the GDPR that allowed EU member states choose whether the age at which children could give online consent or consent to access online services, whether that age should be set as low as 13 or as high as 16. And there was a very significant debate on this area in Ireland. And to our great surprise, the bodies that were child protection bodies, specifically in remit, were the ones that argued for the lower age, because in their view, the empowerment of the child and the access to services was as important and had to be balanced against the data protection rights. Of course, in the end, the age was set at 16. The next thing to mention is communications, guidance, media work. as I said at the outset, there really is a need for data protection authorities to keep communicating outwards, because we're not achieving much if we're locked up doing our own legal analysis and not communicating to allow organizations have a better chance of complying. There's a huge demand for sectoral guidance and more sectoral guidance in the EU. We could see from the sweep on cookies that we did that it's needed in some instances. It's clear that a lot of organizations that we reviewed in the cookie sweep were not deliberately avoiding compliance. They literally didn't understand the rules. And while ignorance wouldn't be a defense, there's still an onus on us, I think, as a data protection authority to try and put out as much guidance as we can to help organizations comply. So actually next week, we're going to publish a 2-year review of the GDPR from the perspective of the Irish DPC. And I think this would be useful in giving signposts to organizations. Coordination with other relevant regulators is also particularly important. We work with consumer and competition regulators through a clearinghouse. We deal with digital safety commissioners. We deal with national cybersecurity. And it's particularly important, particularly in online contexts where the lines can be blurred between areas of regulation, that we keep this kind of coordination with other regulators open and going. Consultation with the DPC on data protection impact assessments that organizations conduct is also a frequent activity, and we're also now consulted ever more frequently. It's an obligation on government to consult us when they're proposing any new legislation that involves personal data processing, which is a lot of legislation, including some very recent legislation, emergency legislation in the context of the pandemic. And we were able to turn opinions on that around very quickly. Data protection officers is also a new feature in the GDPR. The DPC receives notifications of data protection officers that have been appointed. We will shortly start an enforcement campaign against organizations that have failed to appoint or notify a suitably qualified DPO to the DPC. And we are also working on network supports to data protection officers, because having surveyed them in the last year and engaged with them, it's clear many are struggling with their role, where they fit in the organization and what the expectations are. So we plan to do a lot more in terms of supporting DPOs over the coming year. Event engagement like today, very important with stakeholders, recruitment of expert and professional staff, and ongoing training of staff at the DPC. This is critically important. We've grown from an organization of less than 30 at the end of 2014 up to 145 today. And skilled and dedicated people are our number one resource. So even when it's not convenient to take time out to sit on interview boards, this is a high priority. EDPB Article 64 opinions, EDPB plenary meetings, EDPB subgroup. The EDPB is the European Data Protection Board. It is a body created under GDPR. It has limited decision-making roles. It's a topic all of itself, but it's a mandatory area of work for the Irish DPC and all EU data protection authorities. And last year, the DPC attended over 100 meetings last year in Brussels. Now that we're working virtually, the meetings are weekly, if not twice weekly at plenary level, and frequently for subgroups. So a huge amount of work goes into trying to implement a harmonized law at EU level now under the GDPR. International cooperation, also very important. We have lots of contacts with the FTC, the New Zealand, the Australian commissioners, and others. And this is important in terms of understanding the context of what we do. Individual complaint handling, huge area of work for us, and I'm going to come back to that. Investigations, decisions, appeals, enforcement litigation. I'm going to say a little bit more about that. The one-stop shop under the GDPR is a significant area of work, operationalizing how that works. And so it goes on. I'm going to stop with the list of tasks because I want to make just very quickly a few substantive comments about some of the areas. But I hope what that will have illustrated is there are a lot of things that EU supervisory authorities simply have to do beyond day-to-day investigations and complaint handling. Two of the tasks that I wanted to spend just a couple of minutes on are the first task under the GDPR, which is the monitoring and enforcing the application of the regulation. It rolls off the tongue and sounds like a very simple task, but of course EU data protection authorities supervise every single type of entity bar the judiciary. So whether it's a business, a charity, a public sector body, a hospital, a bank, even in some cases individuals, if they process personal data as a controller, we supervise. And so that's hundreds of thousands of entities that the Irish DPC alone supervises, and hundreds and thousands of contexts in which personal data can be processed. So it's an extremely broad-based role. And one of the tasks that we have set ourselves for the coming years is to try and bring clarity and certainty such that organizations know what standards they need to adhere to under the GDPR. So under that heading of monitoring and enforcing the application of the GDPR comes the supervision of big tech platforms. And those of you that are following current affairs in EU data protection will know that the DPC put through a decision 3 weeks ago for consultation with other EU data protection authorities in respect of whether Twitter has complied with its obligations to notify the DPC on time of a particular breach and whether they documented it correctly in accordance with Article 33.5. And as I said earlier, there are so many breaches notified day in, day out in the EU. This is a niche but very important case in attempting to bring legal certainty and clarity to the interpretation of that article that's deployed every single day. The next case we're going to bring for consultation with the other EU data protection authorities is likely to be a case involving WhatsApp and its compliance with transparency obligations under the GDPR. And I say it's likely to be the next one because we've actually gone out to WhatsApp with a preliminary draft of my decision in that case, looking for their final submissions. And we've 19 other big tech cases underway. They're into various articles of the GDPR around legal basis, transparency, security measures that have been implemented. A lot of the investigations or inquiries that we've launched, they've been at our own volition, but equally quite a number of them have been complaint-based. And some of those complaints have been lodged by NGOs that represent complainants. But actually, if you've read any of the complaints that they've published, that they've lodged with DPAs, you'll see that often the complaints are really very broad-based dismissals of the legitimacy of the personal data processing of the various platforms. I can use the fingers on one hand to count the number of multinational final decisions that involved fines that issued across the EU data protection authorities under the GDPR in the last 2 years, because there have only been 4. 2 are from Malta, 1 each from Latvia and Lithuania. You're unlikely to have heard of them because they didn't involve any household names and they involve small multinationals that operated only across 1 or 2 countries. And that's okay because actually when you think about it, well over 95% of the organizations all of us supervise in the EU are SMEs or public sector bodies. So it isn't all about big tech platforms and huge multinationals. But given that at EU level, including in the case of the Irish DPC, there have been fining cases concluded in much larger numbers against domestic organizations as opposed to multinationals. We might ask why cases involving the big tech platforms take longer than those 4 that were included by Latvia, Lithuania, and Malta. In fact, it's because the data processing operations, I think, are considerably more complex in the case of platforms. There's an increased number of EU data protection authorities involved. There's much more work to be done around the competition law concepts in the GDPR around undertaking to ensure that a fine could be correctly implied. And these are just some of the reasons. I realize, Justin, I'm probably going to run way over time. So I think I'm going to cut through to the second area that I wanted to deal with and wrap up in the next 5 minutes so that we will have some time for the Q&A. Otherwise, I'll talk down the hour, I'm afraid. So just to move on then in terms of, I suppose maybe before I move on to talking about individual complaint handling, I might just finish out a little bit on regulating the big tech companies and why, for example, it's not always easy to conclude these cases quickly in the way that some commentators might anticipate. And in that context, I want to mention that there's a clear theme in the focus of NGOs in the EU around the social media platforms. And I think we could say that that relates to the fact that they offer free of charge services instead they derive their revenue from ad serving, rendering ads to users based on profiling and data collection in different ways. And I don't think anyone would disagree, but maybe the audience will, with the idea that there isn't really a consensus around that debate about free services versus profiling and whether it's a good or bad thing. Some argue that going back to the 90s, society should have made the choice to make the internet subscription based, but instead, of course, the democratic, freely accessible philosophy held sway. And today we see that, for example, in the context of children, many people are opposed to the serving of ads, even contextual ads to children, where there's no personal data collection involved, while others approach it from the point of view that there's far greater value in making sure that as many children as possible can access high quality content and that it's appropriate that that's funded through the revenue generated by ad serving. So what I wanted to say about big tech in part is that it strikes me that the world may need to have a mature debate around this whole issue of ad-funded services and the competing values that underpin it, with a consideration around those competing rights of access alongside the right to data protection, because it strikes me that chipping away at it case by case may not be the smartest way of effecting fundamental changes to business models, if that is ultimately where we're trying to go. So just to move on then and deal with individual complaint handling, I mentioned this is an obligation of EU data protection authorities. Every individual that considers their data protection rights may have been infringed has a right to lodge a complaint. And this takes up at a minimum 40% of the resources of the DPC. The Irish legislation that implemented the previous directive to the GDPR, it required us to actually not just handle every individual complaint, but to investigate it if the complainant required us to do so, and to issue a statutory appealable decision in each case. And in fact, we're still finishing out 99 cases under that older regime. In parallel, in the last 2 years, we've received over 15,000 individual complaints under the GDPR in Ireland, 80% of which we've concluded, often with information to the individual. I want to, in the context of just mentioning individual complaints, which as I said is hugely resource intensive, and to come back to the comment I made at the outset that sometimes data protection is made more complicated than it needs to be, I want to just briefly mention my favorite Advocate General opinion from Europe's highest court, the Court of Justice of the European Union. And I do acknowledge it's very sad to have a favorite Advocate General opinion. But in any case, it's the opinion in the Regas case. It was case C-13/16. And in that case, Advocate General Bobek was compelled to write at the end of the opinion that he offered to the court that ultimately sided with his opinion. He wrote something called a data protection protective epilogue, and I often recommend people read it because he said that looking at the series of events in question, an uninformed bystander might raise the innocent question, should the issue of an individual request for the identity of a person who damaged the individual's property and whom the individual wishes to sue for damages really be a case in which the police officers are obliged to carry out several layers of balancing of interests and proportionality, followed by a protracted litigation and an opinion from the National Data Protection Authority, and of course, ultimately a reference to Europe's highest court. And he said in that case that data protection laws in that instance yet again appeared to reach into and were being employed in rather surprising circumstances. It generates not just for the uninformed bystander a certain intellectual unease as to the reasonable use and function of data protection rules. And he said, in some, common sense is not a source of law, but it certainly ought to guide the interpretation of it. And actually his comments in that case were largely about how data protection is of primordial importance, but its main function, its primary function, is to regulate large data sets, large scale profiling, rather than requiring written data protection impact assessments in the case of the question of one access. And of course, in terms of the individual complaints we deal with, it's impossible to convey this to individuals who quote their fundamental rights to us, even though the issues are of no systemic importance. So individual complaints vary hugely. Our decisions can be up to 60 pages long, hugely complex sets of facts, spanning many scenarios. There's no statute of limitations on complaints under the GDPR, so they can often concern very historical facts. Multiple parties can be involved, obliging us to trace very difficult analysis of controllers and processors that doesn't easily fit. Over 30 litigation cases are ongoing in the Irish courts against decisions of the Irish DPC. And as I said, they're often not systemic issue cases. There's an EU lawyer, a Dutch-based lawyer called Jeroen ter Stege. He has pointed out that the GDPR has become the law of everything. And I would add to that it's become the law of everything and the law for everyone. So where the GDPR doesn't set any boundaries on the types of complaints that can be taken and doesn't allow us any clues as to prioritization, the volumes for all data protection authorities continues to grow. And for the avoidance of doubt, I'm in no way opposed to individual complaint handling, but I believe that there need to be more rules and parameters along the lines of Advocate General Bobek in order to ensure effective use of what are very limited resources. So in conclusion, I did want to mention that I don't believe there's a consensus around a lot of the major big data issues of our time. And I mentioned the free services in exchange for profiling. I think there is an absence of policy debate on whether the oppression of the constant tracking of ourselves offline and online to ever more accurately reflect back to all of us what we should buy, think, read, and listen to, whether that is out of balance in terms of the convenience that we gain and the right of access to services free of charge that we derive. I think we need to do more debating of all of those concepts. I think by delaying the conversation that goes round in circles on ad serving, we could be distracting ourselves from bigger issues in data protection to do with artificial intelligence, facial recognition, and so on. And I think we need to be very careful about statements that suggest if there was more or faster enforcement under the GDPR, X, Y, Z would no longer be happening in a social media context. Academics aren't universally convinced. Justin, you mentioned at the outset the idea of control for individuals. Academics aren't universally convinced about that idea of giving individuals more and more supposed control over their personal data to improve their lot. It puts lots of burden on them, and it may not address the structure or architecture of information collection. So Woody Hartzog, as you know, suggests that control is not the right focus. Daniel Solov has also written a paper on the privacy paradox, where he suggests that focus shouldn't be on giving individuals more tools to control, which is a full-time job as it is, but it should be around addressing the structural issues. So it's critically important that we perhaps have the great conversation so that we can move on to data protection by design and design of something that reflects the values that we have decided are the most important. The Irish DPC is committed to its role and all of its tasks that it's assigned under the GDPR. It places significant obligations on us, but I think nobody should be under any doubt but that it's a long-term project. In 2 years, it couldn't possibly hope to have achieved everything. The DPC is also very much committed to regulating all major processors of personal data, be they big tech or government departments, and decision-making, including fines and corrective powers, has already started and is beginning to flow through now. So I'll leave it at that. I just want to keep talking, but I can't cover it all in the time.
Well, no, Helen, that was a tour de force of just explaining the breadth of the remit for your office. And I mean, there is an incredible number of topics we could cover. And as you've probably been watching, there are questions coming in over and over. And as always, we're going to end up with far less time than we wanted. And luckily, you're speaking on an EU panel tomorrow with some other phenomenal leaders. So we'll be able to address, I think, some of them. I'm going to try to be crisp here because we only have 10 minutes or so. Maybe I could start with this bigger picture question. You have an enormous remit, and there was a lot of conversation coming out of your office, certainly in the last year, about momentum behind some of the bigger investigations that you have in process. And of course, you're always trying to balance the investigations against the due process requirements that you have to face. There's a very tough balancing you have to do. And of course, against all of the individual complaints that you're also focused on. So my first question is, in the current context where the whole world has shut down, how have you seen that affect your work and your priorities in this last year? And can you, I will ask this, how can you imagine that affecting your ability to enforce, given that most of the companies you're working with have also been shut down? Because there are priorities that I think a lot of the world is going to look to you for on bigger picture issues. Are you interested in notice? Are you interested in use and processing? Are you interested in privacy by design? And a lot of those investigations and where you choose to go will end up driving, the private sector agenda. So my first question is, how has COVID affected you? How has it affected your agenda?
Yeah, well, I don't even need to imagine how enforcement is going to happen, because enforcement is happening. Since the restricted movements have been implemented in Ireland and elsewhere, we've imposed 2 sets of fines on organisations in Ireland. And that organisation is no doubt affected with remote working, as many of us are, but they have continued to engage with us, and we've experienced no issues in terms of the procedures that we needed to fulfill. And we've now made an application to court to confirm those fines, which is required under our legislation. I suppose that's one area where we're seeing a little bit of delay, because the hearing date that we've been assigned is for November 2020, which is a lot later than we would expect, but it is a formality. In terms of the investigations we've underway, the inquiries into big tech organizations, none of us are shut down. We're working remotely. Look at this fantastic virtual conference you've implemented. We're having a conference. We're not locked up and not communicating with one another. And that's exactly the way enforcement is working. We can still write letters, we can still write emails, we can still engage in desk-based investigation activities. And of course, I mentioned earlier, we've started that so-called Article 60 procedure of consulting the other EU data protection authorities in the last 3 weeks. So if anything, for us at the Irish DPC, where all of our staff have remote access, we are finding the elimination of travel to Brussels and a lot of the activities that went with that is allowing us a unique time of focus where we're really able to progress. So we've had one or two requests for extensions in terms of making submissions to us from big tech companies. We've assessed those case by case. They haven't been in any way unreasonable. They've really reflected the logistical issues around legal advisors and staff working remotely, and we've been happy to grant extensions in the order of a couple of weeks. But for us, enforcement has to continue. We'll listen case by case to any reasons an organization might have to delay. Another practical example, I suppose I might mention, I mentioned that we're conducting inquiries into use of surveillance technologies by law enforcement authorities in Ireland. We've concluded some of those, and in some of those we've required organizations to implement new public signage to warn that there's surveillance in progress and so on. And they have written to us and said that may be somewhat delayed in implementation for practical reasons. But beyond that, it's all systems go, and I don't think it should be any other way.
Well, look, that's an important thing to convey, because there is thought about that. You know, how is it practically done? But that brings us to another one, and this may be our last question, Helen, because we only have a few minutes. But the healthcare issues and the COVID tracking issues themselves are just enormous. I mean, companies are dealing, and people. Myself, I received a notice yesterday from our Little League, our baseball Little League, that before every game, we're sending in information, sometimes by hand. We have to show up and sign it about our healthcare status at the moment. I know there have been 28 different issuances of COVID guidance, and obviously this must be something you're spending a lot of time on at this point, but the depth of complication on these COVID tracking issues could take up your entire agenda by itself.
Yeah, it's a huge area of work and focus for us at the moment, and new issues arise every day. But I suppose key for us in this jurisdiction, and I think it's the same in every jurisdiction, is the actions that any organization takes around tracing, protecting. They have to be linked to public health advice, and public health advice that's really aimed at measures to contain the pandemic. So, for example, there's been a huge amount of talk about thermal checking and temperature checking, and yet our Chief Medical Officer in Ireland says the evidence around it is non-conclusive. It's not something he recommends. It can also, high temperature can be suppressed by taking, Panadol, paracetamol, or ibuprofen. So it's easy to scam it. So in those circumstances, if you're going to have extensive data collection flowing from thermal or temperature checking, in circumstances where the public health advice is it's not useful, then you really need to do a very careful necessity and proportionality test to demonstrate why, as an organization, you would implement such. But you mentioned form filling and providing information in advance. In Ireland recently, the government launched a return to work protocol. It has a lot of form filling in it, pre-return to work forms, filling out of any group that gathers. And we've sat down with the government department that launched that, unfortunately, without talking to us first. And we're trying to step through with them, well, what does this form filling actually do? What purpose will it serve in terms of protecting anyone? Or is it just an activity that makes everyone feel better because we've got a pile of paper? And when you dig into these issues and understand what's behind the activity, I think that helps you make the assessment as to whether there's any necessity or proportionality. So I think it's a matter of really taking each proposal in turn and ensuring that people aren't just running around like headless chickens. There's a lot of copying what everyone else is doing without really thinking what its purpose is, or what purpose it serves as well, which we're trying to calm down on.
No, I mean, I agree with you. It seems very random, but there's a panicky quality that I see about what's happening, you know. And one of the things we've seen companies we're working with worry about is, in the absence of a very clear structure, you could just have people emailing around, I heard so-and-so has this disease, which is just your worst nightmare if you're worried about privacy and data protection. And it's not obvious the benefits from either a public health or a human rights perspective out of that. It becomes very one-off. So it's a huge set of issues. So Helen, you know, there have been a lot of questions that came in for you. One of the things we will do is we'll gather these and at least present them for you. And maybe some of these are ones that we can use in the follow-up session we have tomorrow.
Great.
From our perspective, since we only have a minute or so left, let me just say you covered an incredible amount of information, including the breadth of big investigations and platform investigations, the scope of the number of individual investigations, but also the number of other policy and legislative issues that your office is driving at a very, very tough time for all of us. So, on behalf of the community, I will say thank you for all you're doing. You know, I know it's tough. I know you face a fair amount of, just like everybody, this is a community that's used to being criticized because there are very difficult calls we have to make. But I do appreciate you taking the time to lay out all of the things you're covering, and we'll go deeper on some of these issues in tomorrow's session as well. But
great.
But I do appreciate
I look forward
it.
to
Thank
that.
you so much for joining us for our keynote opening session today. And we'll make sure to bring the other questions up for you tomorrow.
Great. Thank you very much, Justin.
Thank you. Thanks, everybody. Okay, and our next session begins in about 5 minutes. It's our privacy leader session with Bruno Gencarelli from the European Commission, Julie Brill from Microsoft, and Keith Enright from Google, an absolutely terrific panel. And it'll be followed by our coffee connections. And then later on this afternoon, we have a panel that's completely focused on COVID and then marketing. And Helen, to the point you were covering, they're really going to be talking about what does the marketing world look like and in the next 5 years. Don't think about today, but where are they going with the use of observable and observed data? And then, of course, tonight we're ending with cocktails and small breakout sessions to reconnect with the community. Everybody, thanks for joining the session today, and we'll see you at the next sessions. Thank you.